Is that a yes or a no?
It's a no, Your Honor.
That's what I thought. Take him into custody.
No, 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 no. No, 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 no.
Haiti Oropesa, thank you for tuning in to Florida You Judge. I am here with a very good colleague and friend, Patrick Leduc, who has an incredibly interesting case that just arose recently. His client was arrested and for a misdemeanor amount of pot, and thereafter law enforcement sought to going through his two cell phones. They obtained a search warrant, and so today we're going to be discussing the issue of the challenging a search warrant prior to its execution, because his client has resisted efforts to or not resisted efforts. Pat, if I am incorrect in any of the factual recitation, please jump in, but he forgot his passwords to the cell phones that the government is seeking to search through, and so he was recently held in contempt in Hillsborough County by Judge Holder. And so, Patrick, thank you so much for being here.
No, thank you for having me. Thank you.
And I also have in studio telephonically appearing Warren Redlick, who is also an attorney here in the state of Florida, and he practices out of South Florida and Palm Beach County. Thanks, Warren, for also joining into this very important discussion.
Thanks for having me.
You're always welcome, Warren. Listen, Patrick, tell us a little bit about a brief history of this case and how it has evolved.
Well, my client, his name's William Montanez, he was leaving a gas station. It was like 21 June, along that, on or about that date. He was leaving a gas station, he was pumping gas, and as he was coming out of the gas station, he, like most of us, he didn't stop. He just merged right onto the street and onto traffic. And apparently there's a Florida statute that says that you have to come to a complete stop before you enter traffic at the sidewalk. So that might be news to all of us who every day when we leave our garage, if there's a sidewalk as we're coming down the driveway, we're supposed to stop, come to a complete stop before we then back out into the road. But neither here nor there, he was pulled over, and before the police officer even made contact with Mr. Montanez, he had called for a K-9 unit to the scene. And then he made contact with the defendant, took his license registration, and at which point the K-9 unit showed up. The dog alerted. They conducted a search of the vehicle and found inside the vehicle a misdemeanor amount of marijuana, a baggie, which they alleged was drug paraphernalia. They found 2 oil vials that they claimed tested positive for THC oil, although the defendant denies that he had THC oil. The defendant was driving his mother's car. His mother has a carry concealed permit, and in the glove compartment was her handgun. But they charged him with carrying a weapon in commission of the felony, specifically the THC oil. So that's all to be determined. In any case, the defendant admitted the marijuana was his, and admitted that he smokes marijuana. There was 2 burnt roaches in the center console. The mother showed up on the scene, took possession of the vehicle, and as the defendant was being arrested, he had secured the 2 cell phones that were on my client's possession. It was on his person. And on one of the cell phones, his mother apparently had texted him earlier, OMG, did they find it? We don't know what it is. My suspicion is she was talking about her handgun. But in any case, the arresting officer determined that this was evidence of some nature to which he put great emphasis on this, seeing this text message, OMG, did they find it? And so he, the next morning, he went to get a search warrant, and the search warrant only had 2 paragraphs to it in terms of the probable cause affidavit that was relevant. Basically, was very bare bones. That I arrested the client, the defendant. He was arrested for possession of marijuana, possession of drug paraphernalia. This was a handgun in the glove compartment. We believe he had THC oil. And we found 2 cell phones on his person, and we believe there's evidence on the cell phone related to criminal activity, and we want to search the cell phones. They delivered a search warrant to the defendant some days later, in which between that time he had hired me. They demanded that he open the cell phone. The defendant refused to do that. They then proceeded to do an order to show cause, and that hearing took place on July 3rd before Judge Holder in our first appearance court. And at that time, I wanted to attack the basis for the warrant because the warrant itself was not based on probable cause. There really isn't any probable cause. There's been the probable cause affidavit or the affidavit to support the search warrant did not provide any information that would tie the cell phones to the offenses for which the defendant was arrested.
Okay, Patrick, let me just interject real quickly. So the officers, I did read the search warrant. They're trying to search because they say that they want to go through a wealth of information, images, text messages, files, telephone numbers, la 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 la. The search warrant is available online, FloridaUJudge.com. Go on there. It's posted. You can hit the link and read
And
it.
all of that, by the way, is boilerplate. And
Right,
all
no, I
that stuff that
understand.
they're looking for is typical boilerplate.
I understand. So what I'm asking you is the only thing we have the THC oil. You're saying that potentially is a felony? Is that a felony?
They're charging that as a felony, as
Okay.
possession of a controlled substance, but it could be a false positive.
Okay, so they have a misdemeanor amount of pot and a gun that's lawfully owned by the mother. It's the mother's car. The only thing in the search warrant that I'm seeing as to their reasonable basis, assertion of fair probability that evidence will be found in those phones, is the finding of a misdemeanor amount of pot with the THC oil and a text message that pops up by the mother. Was that the mother's text? Do you know, or who?
Well,
do we know?
at the affidavit did not know who it was from.
Okay, so-
I've been able to determine that because I've spoken to mom.
Okay.
And mom has told me that was her text to her
Okay,
son.
so we have a misdemeanor amount of marijuana, THC oil, and a text from the mother saying that they find it and we don't know what it is. Those two things, Warren, do you think that rises to the level of probable cause to go into two cell phones? And listen, folks, it doesn't matter who you ask, whether they're conservative or liberal, whatever color label or banner they affiliate under. Anyone that you ask going through a cell phone nowadays, currently in the time that we live in, this is a huge invasion of privacy. So you ask anybody, would you mind if government goes in through your cell phone? Go ahead and ask the judge who made a determination that there was probable cause, or any judge.
Or in this case, 2 cell phones.
Okay, the government itself, government officials, if they would mind having us go through their cell phones to see if they're okay with that. Warren, do you think there's probable cause here?
I don't see it. I have a more restrictive definition of probable cause than maybe some judges have. I can sort of see the hint. The problem is, probable cause for what? You found the drugs, you found the guy, he's in possession of them, he doesn't deny he's possession of them. What's the potential crime? This is the thing that maybe Patrick can answer this. What is it that they hope to discover when they get this? I mean, they're not going to find more proof the guy possessed the drugs.
He denies.
Are they hoping to find a criminal conspiracy over 10 grams of pot?
He denied.
No.
He was asked.
Not enough pot to have a conspiracy, really.
He was asked if he was, he said, "Look, I smoke marijuana. The marijuana in the car's mine. I'm not a drug dealer." And that is in the police report. That's in the police report under the statements made by the defendant. And none of that, I might add, none of that information made its way into the affidavit. The affidavit, there's lots of things that are in the police report that aren't in the affidavit, which I find interesting. It's not just what's in the affidavit, it's what was omitted from the affidavit. I would think that the court would want to know, well, did the defendant admit the possession of the items found? There is nothing in the affidavit to support the search warrant that talks about any of that. I think that would be important. A judge would want to know. Well, the defendant admits that all of this is his, and he denies being a drug dealer. What this is a fishing expedition. There's no other way to say it. It's a complete fishing expedition, and this warrant was improvidently issued. And I use the term lightly, but there's no limiting principle here. If the police arrest you for any crime whatsoever, whether it's drugs, whether it's possession of a firearm, whether it's possession of any type of contraband, not even think drugs, think of, whatever you want to claim is criminal. Let's say you were a DUI, you're driving under the influence. the police could then, if they can convince a magistrate or a judge to issue a warrant, they could seize whatever electronic devices are in your possession and search them.
Okay, so citizens, viewers, that could be where we're headed. What has the Supreme Court recently stated as far as cell phone searches? And that either of you can answer that.
Well, a Carpenter case, there's a couple things. The Carpenter case that the Supreme Court just recently came out with applied under the issue where the police went and got information without a warrant. And the Supreme Court said, hey, look, if you're going to get third-party information, you have to have a warrant. The police were under the idea that they didn't need the warrant because it's third-party information, and then therefore you didn't have a reasonable expectation of privacy, and so we can go get it. The Supreme Court held that no, when it comes to like your cell phone, in this case, the cell phone my cell phone that's on my person is telling the world that I'm in this studio right now. If the police were able to go and get that information, they could determine every place I has been and how I got here. Well, in that particular case under Carpenter, the guy was a bank robber, and so they used those records to determine that the guy was near these 6 different banks that all happened to be robbed, and he happened to be right where those banks were when they were robbed. So that's important information. But they didn't get a search warrant to do it, and the Supreme Court held they had to get a search warrant. There's a case locally called Stahl, which is from the 2nd DCA. That's more relevant, and that deals with the Fifth Amendment. And in Stahl, it involved a guy who was charged with video voyeurism, and he was seen by the victim using his cell phone to take pictures. And in that case, the guy didn't want to give the passcode because he said that would violate my Fifth Amendment right. And the 2nd DCA held, well, wait, the passcode itself is not protected by the Fifth Amendment. And so Stahl is not applicable to this case either, because at least in that case you could tie a direct nexus between the cell phone and the crime. Here we've gone a bridge farther. There is no nexus between the cell phone and the crime. What the police are saying is the crime allows us to search your cell phone.
Right.
If we can get a warrant.
It doesn't matter whom I've asked, and I've asked a wide spectrum of persons from different philosophical perspectives, and you know what? No one's seeing it. I wanted to ask Warren. This is something unusual. I think as criminal defense practitioners, we typically, the run-of-the-mill scenario is challenging warrants after their execution, meaning the privacy right has already been violated. We certainly know that at times warrants or seizures are thrown out, suppressed, because a warrant is after its execution found to have been defective. I've asked a couple of colleagues even appellate attorneys, one yesterday, who typically, it appears to be a case of first impression in that we don't really see challenges to warrants prior to their execution. If this becomes a routine practice, it appears we're gonna see more of this. Do you have any thoughts on that, Warren?
Well, there's 2 things. First of all, like I said, it's not clear to me, going back to the probable cause issue, it's not clear to me probable cause for what? If it's probable cause to say that this guy possessed drugs, you already have it. Is it probable cause to look for someone else? Was that? I don't have the affidavit. Was it spelled out in the? And I guess from what you said, it's not.
No.
The affidavit say what crime was suspected?
No.
You know what? Yeah. So that's it. So anyway, but this issue about the cell phone, you know, I'm not sure whether, and maybe Patrick would know more about this. Can they order you to give your passcode? That's, you know, and I don't buy that. I don't remember my passcode argument. That me
Warren,
personally, I don't buy that.
Yeah, Warren. Here's the issue on that. To answer your question directly on that passcode issue, he doesn't. By the way, he doesn't remember the passcodes, nor will he ever remember the passcodes. He's going to be stuck there for the next 6 months if we don't get some relief. But to your answer,
yeah, Patrick, this is what I want to try to understand, because from what I've gathered based on the reports that have been put out by local media outlets, Judge Holder, you asked the ability to have a review of the warrant so that you can challenge the lack of probable cause. So because if probable cause is not found, therefore the contempt that's in place right now is gone. Yes?
Yeah, here's the problem. It's and let me give you the analogy. Yeah, to answer your question directly, then I'll give the analogy. the warrant's issued, and and now he's being ordered to show cause why he shouldn't be found in contempt if he doesn't release the passcodes. So let's just assume for the sake of argument he does remember the passcodes, and he could do that. I want to be able to attack the warrant and say, look, the basis for why you're ordering to show cause, which is the warrant, I want to be able to show cause why we shouldn't be able to comply with the warrant. I want to be able to say the warrant isn't based on probable cause. It was improvidently issued. The response is, that motion, you have to bring that motion when he gets to the circuit court, the division. You can't bring the motion here in first appearance court because the administrative order doesn't allow me to receive that motion.
So
I can only
determine.
determine.
No? The judge told you no?
Right. He wasn't going to hear the motion because he didn't have jurisdiction to hear the motion.
Okay, not because he didn't want to.
Not because he didn't want to, because he didn't have jurisdiction.
Okay.
So there becomes a procedural and a substantive due process issue. My client is now being deprived liberty, but he hasn't been able to be given any due process. And the only person who can deal with the contempt is a judge who doesn't have the ability to deal with the underlying issue, which is the warrant. So
I know,
there's no
Patrick,
due process.
that you've been practicing for a long time, and I know that you have as well. Warren, I've asked a multitude of attorneys if they've ever seen a practice where the criminal defense attorney moves to quash a search warrant. I had a colleague yesterday say I've moved to quash arrest warrants, but not search warrants. Have you ever seen that, Warren or Patrick?
No.
No.
Okay, so I've looked through our criminal procedural rules here in Florida. I haven't seen the mechanism to allow that. I know I ran upon a case online. Facebook, on behalf of its users, sought to move to quash a search warrant in New York, and that was denied. And so it was executed. A blogger cited to a Fourth Circuit federal appellate case out of Virginia, and that case dealt with a discussion as to the inability of the defendant to, or one of the parties to, challenge a pre-executed warrant because they referred to the element of surprise and speed. And I can understand in practical terms when you're dealing with, if you get presented with a search warrant to search your home and you resist saying, oh wait, I need to schedule a hearing to quash this because I'm gonna challenge the lack of probable cause. I can see how there's a problem with that. But in this particular case, one can very persuasively argue that the phone right now is in the possession of the government. There is no ability by Mr. LeDuc's client to tamper and to take away or have a concern as to the issue of surprise and element. Do you agree with that, Warren? Should there be, I don't think there's any statutory case law or anything which there's no prohibition in the state as to request a hearing at this juncture prior to the execution and the potential violation of privacy, which would be irreparable because once you do it, that's it.
Well,
as you cited, LeDuc, in your writ, that once the horse is out of the barn, that's it.
Yeah,
It's done.
here's the analogy. This is the perfect analogy. I have classified information. The court orders me to release the classified information. Now, it's the release of classified information that's the damage. You can't fix it once the information's out. I can't put the genie back into the bottle. Once you have spillage of classified information, there isn't an ability to say, oh, go bring a Fourth Amendment motion to suppress. The information is now out there.
Right.
It's out on the internet. You can't, it's out wherever it's going to be. And as we all know about the internet, once it's on the internet, you can't get that genie back. So here's why the issue is important. The mere ability to go through my phone, even if you don't want to use that information, you have violated the very thing that I'm trying to protect. You have secured the classified information. Now, if you order me to release the classified information, you can't give me a remedy later.
Right.
The information's gone. The thing that I'm trying to protect, classified information we put in what we call SCIF, a special compartmentalized information facility, okay, or a classified information facility. It is a facility that has, locked doors and fences, and you have to have codes to get in. Why do we do that? Because we want to protect the information. What do we do with cell phones? We lock the information behind a passcode. We want to protect that information. As we're fully aware, there's been a lot of controversy lately about what Facebook and all this information that's out there, and is it being sold to third parties, and is our protected information being protected? A cell phone is far above Facebook because it's on my phone. protected behind my passcode. And now I'm being told to release the information and because the government wants to just look at it because they say they can. And then I'm being told I can't challenge that because, well, we got a warrant and you can't challenge it. You have to give me all the information. Doesn't matter that your privacy's damaged. Just try and get that horse and put it back in the barn later. It just doesn't work.
I could just chip in one thing here, Haiti. That
Absolutely, please do.
When I reviewed the documents, I just saw a little bit of the case. The one thing I would say that this is an example, and this is a passion of mine, is I don't think it helps most defendants, most people who are stopped by police, when they talk. I don't know if Patrick wants to comment on this, but I don't think, from what I see, I don't think the defendant helped his case by speaking.
And thanks, Warren, and I want you to continue on that. You know why? Because I know that you're a very ardent defender of the Fourth Amendment. You've even put yourself at personal risk and danger in challenging a DUI checkpoint a couple of years ago. So tell us in practical terms, what would you advise? Because I think this is going to become more of a routine thing with law enforcement trying to go into our cell phones. What would you advise?
The first of all, the thing is that you shouldn't speak at all.
Right.
So when you encounter the police, I think a lot of people have the impression or the sort of gut reaction that if I just talk to them, then they'll be nice to me. And the reality is that if you talk to them, you're giving them information they can use against you later in court.
Why can't Americans at this juncture where we're at in our country's history, why can't Americans understand the simplicity? Geez, my parents came from Cuba, okay? I'm the child of Cuban immigrants that fled from tyranny and government overstepping people's civil liberties. And I understand that. You're not supposed to talk. You're supposed to assert your Fifth Amendment. Why can't Americans understand that?
I think that first of all, I think people don't think about it much. And when they think about it, they think it's about other people. And it's only when it's them, and then they realize, gee, this isn't as easy as I thought it was. And the simplest thing to do, it's hard for people to grasp conceptually, but once you get it, it's pretty easy. Is you just say, either you do it with my way where you hold up a card that says I remain silent, but if you don't do that, you just say, I'm sorry, my lawyer told me not to answer any questions.
What about, can I search your car? Hey, can I search your person? Can I go through your stuff?
My lawyer told me not to allow any searches. My lawyer told me, in this case, I think they didn't ask permission. They got the dog sniff or whatever, which is probably bogus too, by the way.
But you know what? They did reference that, and so because there is a case that says they can't prolong the traffic stop longer than
time.
Go ahead and address that, Patrick, so that the viewers, this segment is for the viewers to inform the public about their rights, so that you can assert them, and so that you don't get caught up in having government trample on your liberties and your rights and the constitutional protections that we all signed up for with this social contract idea. That we'll let you.
Never signed.
Okay.
Signed.
Yeah, the state hasn't. I do have a question though. The state hasn't, to my knowledge, the state hasn't even issued a citation yet. Now, Mr. Falcone, the state attorney at the oral hearing, said that a citation was issued. But what I can say is, at the time of the arrest, my client was not handed a citation for this alleged violation of the Florida traffic laws.
Talk about that in the case that discusses when a canine arrival could be a constitutional violation.
They can't detain you longer than it takes to write a ticket. And what's interesting about this matter is at the time that my client was pulled over, at that very moment, the officer that pulled him over had already contacted the K-9 unit to show up. He didn't even get out of the car. He was already, hey, K-9 unit, show up. And so it really kind of begs some questions. How is it that this particular officer, who's in a street crimes unit, he's not a traffic cop, he's a street crimes police officer or deputy, how was it that he happened to be in this very area at the very time that my client is just coming out of a gas station getting gas?
I think they were, based on my reading of the police report, and let's not go into that, but I think that they had him pegged. They were focusing on him.
They were focusing on him.
And so just know that, viewers, that you can be targeted, and they are just targeting you and just waiting for you to
just
commit a
because
traffic
you're paranoid
violation.
Doesn't mean they're not out to get you.
Hey, do we know if there's video of the traffic stop?
I'm efforting. The case is still young. I think there is video of the traffic stop. I think there's some things that we're going to do to determine, what kind of communications were taking place prior to the stop. How many times, for example, how many times have they been researching our client the month before the stop? I'm going to be
David
interested.
checks.
My client has never been arrested for drug dealing. He does have a history of using marijuana. He's got no prior felonies. He's got several misdemeanor convictions for possession of marijuana. He smokes marijuana. What can we say?
Which I can't let this conversation go without saying marijuana should be legal, and then we wouldn't have to worry about any of this. But go ahead, sorry.
And this gentleman, he is in custody right now, and he can be held there for the maximum of 6 months, right?
Right, he could be held for 179 days. As to your point about legalizing marijuana, of course, that would get rid of a lot of the cases for the defense bar. A lot of I hear a bunch of attorneys out there screaming. It's funny, the state attorneys all want to get rid of, make marijuana legal, and all the criminal defense attorneys like, no, it'd be bad for business. But I
got a buddy who's a defense lawyer in another state, and he does a lot of marijuana cases, and he also smokes marijuana. So we should make marijuana legal. No, we can't make marijuana legal. I make too much money.
it's a bad. The irony of ironies. If they ever had a vote, all the state attorneys would be contributing to the legalized effort, and all the criminal defense attorneys would be contributing to the effort to. No, we want more draconian marijuana laws.
Sadly, that is the truth.
For the listeners out there, this is all tongue in cheek, joking. We're kidding. It is a little bit silly what's happened here. This was not just mere coincidence that my client was getting gas and just so happened to be this particular deputy, and it was just all the stars aligned, and he gets pulled over for what is an absurd traffic violation that you, me, and all of us do daily. So it is what it is. The drug dog alerted, they do the search, they find it. To your point about, I agree with you, people should remain silent. In this particular case, however, it is somewhat helpful that my client did admit that he is, the owner of all this marijuana misdemeanor amount. It was only 4.5 grams of marijuana that was found in the car. So 4.5 grams. He admitted that it was his, because it goes to the larger to the point of, why do you need to search the cell phones again? We
should be clear to listeners that 4 grams of marijuana is a really small quantity.
It's very small. I mean, I don't smoke marijuana, so I can't say any expertise, but my understanding is it's personal use amount.
It's small. It's like personal use. It's like after you use, that's what's left.
Okay, there you go. 4.5 grams is what was found. They did, by the way, that's a good point. They found the 2 roaches in the car that were already smoked, and those 2 roaches weighed 3.7 grams. So the smoked marijuana was 3.7 grams. The unsmoked marijuana was 4.5 grams. In other words, it was basically he had enough for himself. And he admitted, I smoke marijuana, so what? That was the words on the police report.
I'm going to take a quick break. We're going to come right back. There's a surprise guest that's coming on. All right, we're back. My colleague from Tampa, Attorney Michelle Lambo, she wanted to come in and weigh in, and so she dropped off. So we made several attempts. So Warren, I wanted to discuss the aspect of judges in their review, their initial review, because basically they're the checks and balances.
Sure. So my view is that a judge is supposed to be, when they're doing this, they're supposed to be what's called a neutral magistrate. And when you review an affidavit for a warrant, you should demand that a judge should demand that they give you an adequate affidavit. And I've seen it a lot because I used to work for a judge. I didn't work for the judge who gave the warrants, but I worked with a judge, and there were other judges around, and I would be in moments when they were getting warrant applications. And it's sort of like, the cop comes in, they shake hands, they're buddies. The cop says, hey, I need a warrant for this, gives him a piece of paper, and the judge minimally reviews it and just signs off on the warrant. And I think that it's very common that a lot of judges, not all judges, but a lot of judges will sign a warrant without giving it proper scrutiny. And I think it should be more scrutiny than, okay, you wrote 2 paragraphs, good enough for me. And I'm not sitting in that seat. I don't know what they see that's different. I know the practical reality is, one of the harsh realities of this system is, generally speaking, judges are protected by police officers. And it's often the same police agency that's coming and asking them for a warrant. And I'm troubled by that. And this is not just a Florida thing. I've seen this in other states as well. The judges see the cops every day. They see the defendants, the individual defendants, rarely, or not at all in their personal lives and their daily lives. So they come to tend to identify with the police more than they identify with the defendants, and they're supposed to be neutral.
So the only thing that we can do, though, as a remedy for that, since in Florida they are elected, is that whenever there's a problematic case, all that we can do as activists/attorneys is to put the information out there to the voters, so that they can make a judgment call when the next election cycle comes around and that particular judge is asking to have another term. That's all that we can do.
I don't think that's a solution, because voters don't care, or they don't mind if judges give lots of warrants and support the police until it's about them or they always think it's about someone else.
No, I understand, but I think in this
If the cops are the good guys, the judge should be helping the good guys. Why would I vote against the guy who's helping the good guys?
Well,
until it's like, well, wait a minute, until it's me that's being violated, until it's my rights are being violated, my child's rights are being violated.
I don't agree. I kind of see how sometimes, yes, that could be the case when people are focusing on tough on crime and they think about themselves as being a victim. But in this instance, I think if you ask anybody, they would be very offended at the notion that this could happen to them. I think that they would have a problem with that, and I think
I'm not. But I think there's.
Election,
I'm going to say this. I think there's other remedies besides voting, and I think one of the remedies is, number one, what Patrick is doing, which is you go to the circuit court and get a writ, or you can go to federal court and seek, 1983 or habeas corpus or whatever. There are some court remedies that you can pursue. The other remedy, which doesn't sound like it's appropriate in this particular case, but if you see a judge has a pattern of approving warrants based on bare bones affidavits, then at some level you might make a complaint to the body. I forget what it's called, the body that regulates judges. Broward County is not because of issues like this, but Broward County's lost like 6 judges this year already. Judges get bounced.
No, I know, but Warren, I wasn't saying that it was the only solution or remedy. I'm saying that in addition to what Patrick is valiantly and commendably doing, of course.
Well,
yes.
and I think the answer in this particular case, I agree, is we need a rule, and it's not a very difficult rule. There has to be, every constitutional question has to have what's called a limiting factor or a limiting principle. And in this particular case, what is the limiting principle? Well, the limiting principle allegedly is that no warrant shall be given based upon probable cause, right? But the problem with that is it doesn't affect this situation here where what we're claiming is a sort of a rubber stamp warrant. So the limiting principle that needs to be enunciated by the appellate courts is that within the affidavit seeking the probable cause warrant, there needs to be a nexus between the criminal act and the item to be searched. In this case, you need to show how what you're arresting this guy or gal for is directly tied to this electronic device that you want to search, such as install. He's charged with video voyeurism.
I could see where they suspect the person who sent that text message of a crime, but that should be spelled out. We want to find out who sent this message because that person may have committed a crime, but it should be spelled out that what is the crime that you're identifying, say, well, we're trying to find out who sent this text message because that person may have committed a crime and we want to pursue that. Well, I don't think it's enough for probable cause anyway.
Let me push back. What possible crime does a person have to, OMG, did they find it? That's not a criminal act. That's a declaration of truth.
I don't buy it either. I'm just saying that would be it.
I got it.
Michelle's calling in. I'm not going to do the whole redial thing. You're on speaker.
I'm going to let you guys
Michelle, we're on. We're wrapping up.
I'm going to leave you with I remain silent, no searches. I want my lawyer. And I got to go.
Okay. All right, Warren. Thank you for coming on and participating in this very important discussion, okay? Thank you.
Good. Bye-bye.
All right, Michelle, you're on. We're about to wrap up, so anything that you want to add to this issue discussion?
No, ma'am. I just wanted to call in and say I think you guys are doing a great job.
Okay. All right. Thank you. And Pat, again, great job. And some media outlets other than the local ones have
Yeah.
contacted you, and so I think this is a story, an issue case that's gonna stir up a lot of interest, and hopefully it's gonna make great positive changes in the criminal justice system and in our country in terms of the Fourth Amendment and the protection of our privacy rights. Any parting words, anything that you want to leave the viewers with?
I don't know how I inherit these things. It seemed to attract them, but
Where can viewers reach you?
Yeah,
Go ahead and
oh,
give your information.
Yeah, if I real quick, when I was in the Army, I got to do a lot of work at the courts, and I've always enjoyed constitutional issues. It just seems interesting that I get them now, so that's a blessing. If people have questions about this, they're welcome to reach out to me at my office. I'm located in Tampa, in the Temple Terrace area, off of Bush Boulevard, 4809 East Bush Boulevard. My phone number is 813-985-4068. Again, 813-985-4068. If I'm not there, I don't pick up, please leave a message. I'm really good about returning calls, and I will return your call.
Thanks for coming on, Pat.
Thank you for having me.
Thank you. And Michelle, thanks for calling in and saying hi.
And I worked with Pat. He is a very, very good attorney, and if anyone has it in them to fight this fight, it's definitely Pat.
Okay, great.
It's nobody's business but my own. It's nobody's